हाँ
अभी भी कुछ लोग हमारे अदर देन AIFTP मेंबर्स भी है,
हाँ हाँ हाँ।
तो कराने में
Good evening, friends. In the continuous series of income tax topics, we are having a Zoom meeting today, and the topic today is on the practical issues regarding search and seizures. And today's speaker is Dr. Rakesh Gupta. He is a leading advocate in income tax in Delhi High Court as well as Supreme Court, and appearing in all other high courts also. So he is involved in so many important matters which have been there before Delhi High Court as well as before Supreme Court. He has been the earlier member of the ITAT also. Then he resigned and he again came back to the practice. And as far as the search and seizure is concerned, this is his very favorite subject, and he is a very thorough knowledge on this subject. He has written books on this, and recently he has updated his book on the search and seizure in the light of the amendments which have been carried out in the Finance Act and the new case law which has been coming and all that. So in fact, he is very well known throughout India. He needs no introduction, in fact, but he's doing a very good job to the society also by giving so many lectures and educating so many people, in fact, on the subjects of the income tax, being a leading advocate and a knowledgeable person. So now I request Mr. N.P. Jain to give opening comments, and then without wasting much time, we would like to utilize fully the time available with Dr. Rakesh Gupta on the subject, and he will be discussing all practical aspects of search and seizures. Jain Sahab, you may take over, and then
Thank you.
We'll request Dr.
Thank
Rakesh.
you, Gupta ji, Chairman of our Direct Tax Committee of the Federation. And let me confess before respected Dr. Rakesh Gupta ji and all of you that I had the privilege of beginning my practice with the search and seizure cases. And admission and retraction, be it in survey or search and seizure, that has been my favorite subject. So each and every word what Dr. Rakesh Gupta ji will be speaking and deliberating, with full attention I will listen to him, and we all should listen. And some issues Rakesh ji had identified, like what are your rights, case, jewelry and other valuable found in search. What are your rights, statement recorded during search. Then what is the evidentiary value of statement recorded in search, and whether it is different from one recorded during survey. This is very important point. And what are your rights as to retraction of statement? What are the pitfalls that should be avoided while making statement which is recorded during search? And many other facets and aspects of search. Friends, because we would like to listen in depth what Dr. Rakesh Gupta ji has in store, and I don't think there will be any scope of supplementing or adding something at the end, but I also got something in store. So if the time permits, I will deal with that. And now straightway, we proceed with Dr. Rakesh Gupta ji, and Dr. Rakesh Gupta ji's great well-wisher, our Secretary General, Sri R.D. Kakra is also with us, and he suggested me a few days ago that the Federation should have a program of Dr. Rakesh Gupta. Then I requested Sri V.P. Gupta ji to please discuss with Dr. Rakesh Gupta ji. So we got a date. We were in RAC. We got a date after 15 days. So the day has come, and today we are having this important webinar, and I hope all of us will get benefited. We are now nearing 100, already 147. I don't know, the number is rolling. So those who have come for their benefit, I will request Dr. Rakesh Gupta ji to kindly address. Thank you, sir.
Thank you, Honorable President. respected Shri V.P. Gupta Sahab and other office bearers of this esteemed institution. It's a great pleasure to be with all of you through this Zoom link. I had a recess for almost 2 months. I had not taken any deliberations this year on budget because I was traveling. And I had thought that I will be regular to share whatever little I know to my fellow professional friends. Then I got a call from Shri V.P. Gupta ji and I immediately accepted. So this stint of deliberations is beginning. I mean, by this lecture, I am quite conscious that today there is a presence of very eminent persons, including the present officers and the retired officers of the department in good numbers. And let me see, where, does this deliberations take us all? So friends, this search provision under the Income Tax Act is an overriding power of the state. And therefore, the question always comes in the minds of the people that whether such overriding power which is vested in the state, now if at all should exist in any civilized society. Because power of search is something which impeaches upon the fundamental rights of a citizen. Therefore, as I said a little while ago, that this has been a constantly debating point whether such kind of an extreme power now should be vested at all in the state. State itself is very mighty, and state becomes mightier when the statute confers such kind of powers in the state. Therefore, the severity of this action of search is such that we are constrained to discuss about the rights. In fact, the rights and obligations. Rights do emanate from the obligations of the other party. Other party, of course, the state, represented through the mechanism of the income tax department. So the rights are the reverse of the obligations of the department, and rights are not in the vacuum. Therefore, when we talk of rights, now even the board has come out with what are the rights. But then I'm not discussing about those theoretical aspects that one should see a warrant of authorization, one has got right to put his signature. I'm not on those points. Today we'll discuss, as VP Gupta ji has pointed out, that we'll discuss about the practical aspects of the rights and other phases of search. Because ultimately, that is an area amongst the professionals and even amongst the departmental officers also, that we should know that the rights of a person searched now span into what facets and what arena, and the obligations and the corresponding obligations of the department are there in which fields and to what extent. So the first of all, rights of the searched person, because the format of this discussion has been divided by Shri V.P. Gupta Sahab and by the AIFTP in 3 parts: rights of the searched person, statements and retraction, and other aspects. The precautions during the course of statements. So we will discuss that what are the rights for the cash seized in search. Now, seizures take place during the course of search. But what can be seized? Now, if we go by section 132(1), then we find that the warrant of authorization can be issued in certain situations. And one of the situations now which has been envisaged under section 132(1) is that when a notice under section 131 or 142(1) is issued asking for you to produce certain books of accounts or documents, and on the day appointed, such books of accounts documents are not produced. Similarly, if someone is issued or will be issued, or notice under 142(1) has been issued or may be issued, but the date of compliance has not come, and in the belief of the competent authority, such compliance will not be made. And the third is when a person is found to be in possession of any money, bullion, jewelry, valuable article or thing which represents wholly or partly the income or property which has not been disclosed or which would not be disclosed. So having regard to the scheme of section 132(1) as to under what circumstances the warrant of authorization can be issued, now power to seize now flows from this broader power to make searches, and that is why the legislature has used the expression in 132(1) later part as to what are the powers of the authorized officer to seize such books of accounts or such assets. So this qualifying word such, which has been given, which has been made in section 132(1), that speaks that only such books of accounts or documents which have not been produced or which would not be produced, or money, bullion, jewelry, valuable article that represents wholly or partly the income or property which has not been disclosed or which would not be disclosed, are such books of accounts or documents or such assets which are liable to be seized. But during the course of search, the authorized officer has to take a call at that point of time in that kind of an environment to make the seizure. And in that situation, it may happen, it may so happen that sometimes the seizures are made which are perceived by the searched person as if that they ought not to have been seized in the first place. But the fact of the matter is that such assets are seized, and cash is the most liquid asset which is liable to be seized and which is seized. So what would happen in case when the cash is seized in search, then whether there are any remedies, and if at all there are any remedies, then what are those remedies? So first remedy which comes to my mind is, and which I have seen, so must have you, that either we are not aware, or even if we are aware, but then we are found wanting in exercising over that right. And that right is that we have got, the searched person has got right to move a petition within a particular time frame. And that time frame is not very longish time frame, to move a petition to the assessing officer explaining the nature and source of the cash seized and requesting for the release on the basis that this cash, though seized, was explained with the help of these evidences. Its nature was this. And then the assessing officer, with the prior approval of the competent higher authority, who is the principal commissioner or the chief commissioner, then can release that cash. Now, practically, whether that is done or not, and there is a time limit for taking a decision for the release of such cash, the nature and source of which has been explained by the SSE. So first of all, that petition has to be filed within the time frame, and that time frame is within 30 days from the end of the month in which such cash has been seized. I have seen many times that the searched person, the search of whom now takes a much longer period because of the restraint inflicted by the department. Now, whether he would be in a position to move a petition, that too before the assessing officer. Now, the law has got its own strange ways. Now, assessing officers even may not know that his SSE has been searched, because the search most of the times undertaken by the investigation wing. But then the law has been drafted in such a manner that SSE will have to approach to the assessing officer that here is the nature and here are the sources of the cash which has been seized, and therefore, since its nature and source stands explained, therefore it should be released. So the first right, qua explained cash which unfortunately is seized, is to move a petition within this time frame, which is a narrow time frame, to move to the assessing officer explaining the nature and source, so that the assessing officer may take appropriate steps for the release after seeking the permission. There is a time frame, and the time frame is 120 days from the end of the month in which the last of the authorization was executed to release this cash. And I am aware that certain high courts have taken this time limit of 120 days as a gospel and as the final edict of law, that in case your petition has not been disposed, then honorable courts have gone to the extent of directing the departmental authorities to release this. Though there are contrary decisions, contrary in the sense that the High Court has said, has given a mandamus to the assessing officer to dispose the petition. But then this is an area, I mean, on which both kinds of judicial decisions are available. So the first right in respect of the cash seized is that in case of explained or explainable cash, SSE must apply under section 132B within the prescribed time. The second right qua cash seized is to make a request in writing, preferably to the assessing officer or to the departmental authorities to apply such cash towards the existing liabilities. Now, after 1/6/2013, now request cannot be made to make adjustment towards the advance tax. But of course, existing liability and the self-assessment tax liability, now it can be applied for adjustment of the seized cash towards existing liabilities and towards the self-assessment tax liability. Self-assessment tax liability will arise later on. But I'm quite conscious that though the law says that it cannot be applied for the adjustment of the advance tax liability, but then there are judicial decisions to this effect. May not be in good number, but then it is not uncommon either that adjustment of seized cash can be applied by the SSE, or request can be made to the assessing officer to departmental authorities to adjust it. At least it doesn't cost to apply before the departmental authorities. So at later stage, you never know at which stage the necessity or the evidence of the whether you have made any request to the departmental authorities to make adjustment it against the tax liabilities. Now you never know. I mean, I remember in certain situations, despite after the amendment, such kind of a request was made by the SSE in 132(4) itself, in the statement itself. The question arose whether 234B should be applied or not, or 234C should be applied or not. So the courts, I mean, I'm not saying that the strange are the ways as to how the courts interpret the law, but then always have a chance. And you never know, I mean, which argument impresses the court. And therefore, and at the same time, it doesn't cost in making this request to the departmental authorities, sir, kindly adjust it. Now, under the new assessment scheme for the block period, now you are entitled to disclose undisclosed income in respect of any of those block period, or even in respect of the period from 1st of April till the date of the execution of the warrant authorization. So when you make a disclosure of undisclosed income, the taxes on such undisclosed income, of course, you should make request to the assessing officer, and that can be made till the time when you file the return of the block period. And the assessing officer or the departmental authorities are obliged to make adjustment in respect of that tax, which would be there in respect of undisclosed income. So this new assessment scheme for the block period, that is very salutary in certain respect from the SSE's standpoint. Today, the tax rate is 60%. Surcharge, of course, I mean, may be provided in the next finance bill, and that is a different, but today, whatever undisclosed income in the form of cash found can be declared in the return for the block period for this period from 1st of April, the year of such, the 1st April till the date of execution of the last authorization. Now you can make a disclosure in the return of the block period, and then you can request the assessing officer to adjust it. So whenever cash is found and seized, then make a request to the assessing officer, departmental authorities, to make adjustment against such existing tax liability, against the self-assessment tax, and now under the new scheme of block assessment, against the undisclosed income which you declare or would declare in the return for the block period. So these are some of the rights qua cash seized, which I could think, and then I thought that I must share. I mean, I'm quite conscious that I'm speaking before the well-informed audience who are well aware of all these things, but then sometimes it requires a revision on our part to reinforce the things which are latent in our mind to surface or resurface. Now, regarding your rights qua the jewelry seized. Now, you have got, first of all, this right, that the jewelry which stands declared in your wealth tax return or which otherwise could be substantiated with the help of your income tax return should not be seized. Sometimes the jewelries are seized despite having been declared in wealth tax return or under VDIS or under income tax return on this pretext that they do not match item by item. Now, that approach has not found favor in most of the cases from the appellate authorities. But be that as it may, so if the jewelry has been seized, which according to the searched person ought not to have been seized because it was not undisclosed or it cannot be said to represent income or property which has not been disclosed or would not be disclosed, then again, I would fall back on section 132B subsection 1 first proviso, according to which the assessee must come forward, explain to the assessing officer through his petition, which has to be filed strictly within 30 days from the end of the month in which the seizure has taken place, explaining to the assessing officer that this was the explained jewelry. It could not be seized either on the basis of the evidences in the form of wealth tax return or income tax return or VDIS, or based upon the CBDT circular or CBDT instructions dated 11th of May 1994. Therefore, they should be released. But then kindly do mind it. Then please move this petition in time so that in case it is not disposed of, or if it is disposed of to your prejudice, then there may be right by way of course, by way of writ, which can accrue. So this should be taken care. The next important right, and which I always say in the matter of jewelry, that where the jewelries are seized, then of course, if the quantity and quality of that seized jewelry now is contrary to the facts, then it can always be requested to various authorities. Sir, jewelry has been seized. Its quantity and quality has not been recorded correctly. Even today, you get it again inventorized by your own valuer, and quantity and quality, that can be correctly decided. And it so happens on the purity of gold. It so happens about the nature of carat of the diamond. So in respect of, but then in respect of those jewelry which are not seized, which after inventorization is left back, then it is very essential right for an assessee to ensure the thing which I am going to share with you, that assessee has got every right to ensure that quantity and quality of jewelry which is recorded by the valuer or by the searched party, now that should come to be recorded accurately, because that jewelry is left back. And thereafter, if you want to challenge about the quantity and the quality of jewelry, then there are, it is not that easy. It's almost impossible, bordering impossibility. Therefore, quantity and quality of jewelry not seized and left back after inventorization, assessee has got right to ensure that its quantity and quality should be recorded accurately. And it is important from this standpoint, which I just explained, that if the quantity and quality of the jewelry given back to you after preparing inventory, then its quantity and quality, cannot be challenged at later stage. At least, the evidentiary value of that contemporaneous inventorization of jewelry, now that will be one of the most pakka evidences against the searched person, and it will keep on staring at your face. Therefore, It is very essential. Now, the next thing which I am sharing with respect to this jewelry is that, but it can cut both ways. But it has been my experience most of the times, though even contrary can also be given instance. It has been my experience that in the matter of jewelry and cash, the place, the possession and control from whom such jewelry or cash is found. Now, if that comes to be recorded correctly, it gives a long way most of the times in explaining its source. But what happens most of the times? Now, these things found from different possession and control from different rooms, they are lumped together and then they are inventorized together. Therefore, it is the right of the searched person to ensure that the correct location or the person from whose possession and custody these things are found come to be recorded correctly, because later on, now where from it has been found becomes a very important evidence, and therefore this is an important right which a searched person can exert and should exercise. Then if there is some jewelry which is kept with you and which belongs to somebody else, then SSE has got right and should point it out to the authorized officer so that contemporaneously this fact. But then at times there is a dilemma, and the dilemma is that in case it is so stated that this belongs to somebody else, then later on those provisions of section 158 BD now, earlier 153C, and during the intervening period 148 other persons, can be initiated, because 158 BD now says that if undisclosed income found in the search of a person belongs to somebody else or relates to somebody else or pertains to somebody else, then that person, in the lighter sense, will also be treated as if he has been searched, and all the provisions of the search assessment would apply to him mutatis mutandis. So, but then this is a right. In case the jewelry or cash belonging to somebody else is found, then SSE has got right to bring it to the notice of the authorized officer, or otherwise also as early as possible, so that the contemporaneous nature of this important piece of evidence, because the statement which you make at the earliest point of time, more so when you are not tutored, then the legislature puts a strong evidentiary value. So the SSE has got right, to state so that this jewelry belongs, or this right. Now, similarly, right, in case of the stocks cannot be seized. So the first right is that to ensure that the stock is not seized. This is very important, right? Because many times I have seen, more particularly in case of the jewelers, where the bullion is found or the jewelry is found, maybe from residence, then the department says that this is not part of stock. So stocks, even if unaccounted, cannot be seized. But the question is whether it is part of stock. So jewelry and bullion, in case of a jeweler, if kept at the residence, from the security and safety standpoint, but the department says, no, it is, since it has been found at your residence, therefore, we will not take it as stock and therefore we will seize it, is something which needs to be contested and which has been contested and which is contested. So the SSE has a right to contest that the stocks, even if it is unaccounted, cannot be seized. And this is a very important piece of evidence. And where such stocks have been seized on this premise that this is not a stock, then the SSE has got a right under section 132B subsection 1, the first proviso, to explain its nature. The nature according to the SSE, that it is part of stocks which could not be, because there is a specific prohibition under section 132(1) that stocks cannot be seized. So that right to file petition under section 132B in case of jewelry and in case of cash, you are entitled to explain the source of the explained or explainable cash and jewelry. But in case of stocks, even if it is unaccounted, even if it is undisclosed, even if the source of which you are not able to explain, but then if you are able to demonstrate that was a part of stock which ought not to have been seized, yet seized, then you are entitled to file a petition under section 132B subsection 1 proviso, and you must file. Similarly, as in case of jewelry, in stocks also, since stocks cannot be seized, after inventorization, it is left back at your disposal. Therefore, the recording of quantity and quality of stock is very essential, and is very essential, of course, to be recorded accurately. And SSE has got right to ensure that its quantity and quality be recorded correctly. Because if quantity and quality of the stocks is not recorded correctly, when the inventory was being prepared, then you be rest assured that there are very limited window at your disposal to challenge the quantity and quality of stocks at later stage. So you have got an important right to ensure that its quantity and quality comes to be recorded accurately. But in certain circumstances, which are exceptional circumstances, and that too which are based on facts, for which the burden will be very heavy on your shoulders to prove that, sir, even if the quantity and quality has come to be recorded by the department or by the search team on the date of search, but this is not correct. I have come across certain instances where we have challenged this, where the total stocks which have been inventorized by the searched team could not be stored in the premises owned and held by the SSE, because after all, it is a mathematics. If I can prove with the help of the total measurement of the premises which are owned, rented, or are in possession of mine, and the total volume of the stocks which have been inventorized by the department. So, but then again, as I said, it depends upon the facts of each case. The facts may be very peculiar to a peculiar case or to a particular case, but then let us keep them aside, or this much of volume of stocks which have been inventorized within the shortest possible time, which was not possible, which was impossible, highly improbable. So that is a different matter. We are not talking, we are not discussing that kind of a situation. But the bottom line is that since inventory or the stocks are left back at the end of the searched person, therefore the quantity and quality. So if out of the total stocks, some stocks are of spoiled nature. Suppose there are some cement owner. Now in cement, you know that the moment the cement comes in contact with water or moisture, now it's of no use. But nonetheless, the cement is stored in the stack in the in the bora. So if it is not pointed out and is not brought on record at that point of time that out of these many bags, it is spoiled because of the moisture, and instead of cement, it has converted its form in the lump, which is of no use. Then, and if the inventory taking person does not record that this much of stock is spoiled or is of substandard quality, then later on it becomes almost impossible for you to say, no sir, that inventory which was taken on the date of search was not correct. So recording of quantity and quality of those things which are left back at your disposal, that is very, so far as the valuation is concerned. Now valuation can always be proved with the help of the documentary evidence. So suppose if some jewelry or bullion which has been left back after making inventory, and by taking a very high rates of valuation at that point of time, but then you can always prove, sir, if this much of quality and quantity of jewelry is this, now its rate which has been applied now is incorrect because of or in the face of these evidences. So the valuation can be challenged, but not the quantity and quality. Therefore, SSE has got right to ensure that the stocks quantity and stocks quality come to be recorded correctly. At times, there may be stocks now which have come in specie, but then its bill has not come. So SSE has got right to point it out to the searched person, to the authorized officer. Sir, stock, and in the preliminary statement, even this is asked whether the jewelry or whether the cash or the stocks, now it belongs to somebody else, or whether stocks represent some stocks now for which the invoices have not come. It must be you are entitled to bring evidence on record, at least to state that how much portion of the stocks represents such stocks in respect of which you are yet to receive, and it has not been entered in a books of account so far, though the quantity has come. So you have got right to stocks are found in excess, stocks are found in short. But then later on, I mean, it's a matter, I mean, which is of assessment. Now, whether in case of the shortage of stock, additions can be made to what extent, whether in respect of the gross profit, in respect of the short stock, by assuming that the stocks have been sold outside the book. So that is a different matter. But I mean, that will impinge upon the assessment, and therefore, I mean, we can leave that point, I mean, for that stage. Now, apart from cash, apart from jewelry, apart from stocks, now what else are found which are seized are the documents. Of course, if there are the documents regarding which you do not remember, then you have got right to say you do not remember, because you cannot be forced to remember. Now, if I do not remember, I do not remember. So I have got a right that if I do not remember, to say that I do not remember. And one cannot be forced to remember. And even if one applies the forces on somebody to remember, then beyond a certain point, still if he doesn't remember, then nothing can be done. The second right is that if a document can be explained by consulting some other books of account or the document or the passbook, then SSE has got right to demand that, sir, kindly let me see the books of account which are there, with reference to which, because many times there are loans. It's not a test of memory. There are certain transactions, certain documents which contains certain transactions, now which can be explained only with the help of some other books of accounts or the documents of the passbook or the bank statement. Now, SSE cannot be, should not be denied. And in case it is not, the opportunity is not given to the SSE at that point of time, then SSE has got right to say, sir, later on, I will correlate these transactions with reference to the books of accounts. It is a matter of record. Everything is accounted for. And there is no unaccounted qua the entries written on this document. SSE has got right to say. If the document is dumb, and if SSE, as I said, does not remember, then SSE has got right to say that he does not remember. I mean, if the document doesn't have the tongue to speak, then what else can SSE do? The SSE has got right to say, sir, I mean, this is a blind, bland, and bald document. It is a dumb. And if he doesn't remember, then of course he would say he doesn't remember. If the document is electronic document, then there are series of things which the authorized officer should do qua that electronic document. There is section 65B of the Indian Evidence Act. The fulfillment of the conditions as envisaged under that section is required to be fulfilled by the departmental authorities in case of the secondary evidence. And because of the non-fulfillment of those evidences, the evidentiary value of such electronic document now is seriously found diluted by the courts. And therefore, if an SSE, by virtue of this statute made and the judicially interpreted rights, exercise its right at later stage to say, sir, its evidentiary value now is not there because of the absence of the requisite certificate which was to be issued under section 65B, then SSC has got right, and there cannot be any quarrel qua such propositions. He has got right to resist to threats, which will come later on while discussing about the statement. He has got right when the excesses are forced, because of late, I'm quite conscious that my departmental officers friends are also here on this, but then because I get feedback from the field, from the searched persons, that earlier it never used to happen, but now in certain situations, I have found that the departmental authorities have committed excesses, even using the physical force. I mean, though it is not envisaged under the law, it is not desirable. And SSC has got therefore every right to resist such kind of threats. And I mean, let me see when I'll discuss about the statements as to how. So what are the precautions during the statement, which I mean, the searched person should know as to what are the scope of the statements to be recorded, what is the nature of the statement which is to be recorded, and then can act accordingly. So first of all, a preliminary statement on oath is recorded. It's not necessary, but then the authorized officer has got right to record the preliminary statement, and there is a corresponding legal duty or obligation on the searched person to get his statement, which is preliminary, as the name suggests, is to be recorded before the start of the actual search. Actual search means when the search of the premises actually begins, after the search team entering into the search premises. The object of preliminary statement is to know the basic facts to be stated on oath by the person searched or by the person who was there at that point of time. And the objective is to bind as to how much is the cash available, what is the source of it, whether cash or jewelry or some stocks belong to somebody else, or whether stock consists of some part of stock for which the bills have not come, whether where are your godowns, you are partner or director in which companies, have you performed any ostentatious functions, what is the source, how many children, whether they are studying abroad, and so on and so forth. So preliminary statement, the objective is to bind a person, that too on oath, so that if later on he wants to wriggle out from that statement made on oath, then a very heavier burden is cast on his shoulders only. As to why did he state at the earliest occasion in that manner, and now if he wants to shift, he wants to change, then what has led that change? So the objective of preliminary statement, and that the legal power of that preliminary statement vested with the department authorized officer is traced under section 131 subsection 1 capital A. Anyway, then another statement is statement under section 132 subsection 4. When a person is found in possession of any books of accounts or documents, money, bullion, jewelry, valuable article or thing, then his statement is recorded under section 132(4). But at the same time, the explanation has been inserted to say that this statement will not merely be in respect of those books of accounts or documents. It can span through, or it can go beyond the books of accounts, etc., or the assets which have been found, and it can be in relation to any investigation in respect of any proceeding. That proceeding may be of this year, or the proceeding which has been ended earlier, or the proceeding which may begin. So the duty or the right of the authorized officer to record a statement under section 132(4) is quite comprehensive. So we should remember, first of all, as I said a little while ago also, that it is not a test of memory. Meaning thereby that if certain factual thing which is asked the statement can be answered after consulting some documents, then the SSC has got right to say that he needs to consult his passbook. But of course, not to the lawyer, not to the chartered accountant. That right is not there. But of course, his own books of accounts, his past returns. Because as I said, and I'll keep on saying, it is not a test of memory. And SSC has got every right to say, sir, he does not remember. He will have to consult his books of accounts, his returns, the documents, and only then he can answer. Similarly, if the family members are income tax assessees, then they should know the basic facts. They have got right to state those. Suppose if a family member is partner in the firm, and if he's working partner, then he may be knowing about the working because he's being paid on the basis that he's working partner. And because section 40 small b says that the remuneration paid to a non-working partner cannot be allowed as a deduction. A person is a director in a company, family member is a director of a company, then he may be knowing that he is a director, he is drawing remuneration, and in that situation, then he is entitled to reply in respect of his position qua that company, vis-a-vis that company, and then can reply. Therefore, this is not only the right to explain his status and the things flowing out from that status, but it is also a duty of that family member to know the basic facts. Then SSC or the searched person is entitled to know this legal position, that the assets acquired beyond the block period cannot be seized. Can be seized. If it is unexplained, it can be seized. But then, of course, additions cannot be made because anything which is falling beyond the block period, then of course cannot be brought within the mischief of additions. But of course, if there are usufruct out of it, or if there are incomes arising out of such unexplained assets, suppose there were bank deposits, some fixed deposits, which were made outside the block period, then its investment though cannot be added in the hands of an SSC under section 69 in any of the block period, but the interest arising out of fixed deposits, of course, can be brought to tax. And that fixed deposits which represents unaccounted income or some asset which is though cannot be added under section 69 because it falls beyond or it was acquired beyond the block period, but of course it can be seized because the seizure is that of unexplained asset. So SSC should know, SSC is entitled, has got right to know this position. Coded figures, SSC is entitled to know that the coded figures, SSC should not remain under this kind of impression that once coded figures also are liable to be decoded by the tax department. Sometimes that handle is provided by the searched person himself, because there may be some transactions which can be correlated with the bank. Sometimes an SSC may become smart, may try to show smart. Sir, I write the dates in my diary 10 years. The older than 10 years, and therefore they are always beyond the block period, and therefore even if, because the documents found now will have to be believed as it is, there cannot be any approbation or reprobation. Either the document is correct in its completeness. But then if there are certain entries which are correlatable with some other date, now which is more authentic, then of course that document is liable to be decoded. Therefore, while making the statement, one should be aware that those codes which a person believes that they are codes, may well be decoded. SSC should know, because we are discussing about the precautions, SSC should know the theory of presumptions. Because there is a presumption under section 132(4)(a). Now, which has been made for the purpose of assessment under section 292(c). Now, there are certain presumptions which are very important. And an SSE should know, a searched person should know that whatever documents or books of accounts or money, bullion, jewelry, valuable article or thing which are found in possession and control of a person, then there is a presumption it belongs to him. The second presumption is that the contents of such books of accounts or documents are correct. But presumption is only to this extent that they are correct. There is no such presumption that whatever is written in the document represents income. Now, there is no such presumption. Many times I have seen the authorized officer says, oh, presumption is against you. Now, of course, presumption is against me, but only to the extent which the law says. The law says that documents would be deemed to be belonging to you. Second, the contents of the documents will be deemed to be correct. But it doesn't say that the contents of the document will be deemed to be your income. No, there is no such presumption. An SSE should know. And there is a third presumption also, that the signature on this document which purports to be in, or the a document which purports to be in the handwriting of a particular person has been written by him. A document which is purportedly signed by a person now is presumed to be signed by that person. A document which is executed or attested or stamped has been executed, attested and stamped in accordance with law. There is also a presumption, but only to this extent, nothing beyond it. A person is entitled during the course of a statement to rectify himself. As I said, it's not a test of memory. So if a person, while giving a statement, remembers, oh, the position was not like this, it's like this, he is entitled to rectify. The authorized officer who acts as a court of law at that point of time when he records the statement is duty bound to record the statement as it is given. Because there is no malafide or malice, at least in the eyes of law, which can be attributed to an authorized officer because they are public officers. There is a very strong presumption of official acts done in good faith. Therefore, if you rectify yourself, that public officer who is recording your statement, that too as a court, why would? Because there is no personal element involved in that. So you are entitled to rectify. The authorized officer is a duty bound to record your statement as it is. I jokingly say sometimes that English is a very strange language. He works hard. He works hardly. There is a difference. Therefore, it is also equally important for the searched person to ensure that what he states now comes to be recorded correctly by the authorized officer. Sometimes the questions are asked in a series. And SSE may appreciate them, but then SSE is entitled to make a request to the authorized officer, sir, I will answer after understanding each limb of your question. And questions which are not clear, I mean, that person who is giving a statement can say, sir, this question is not clear to me. And therefore, you kindly either clear, or when I am saying that it is not clear to me, kindly record it. And as I said, that if in case you do not remember while giving the statement, you say you do not remember, but never refuse to answer any question. Refusing to answer any question doesn't mean that you remember everything. Do not remember is not equivalent to refusing to answer a question. Now, while giving a statement, one should know to the extent one is supposed to know. Now, in respect of your family members' affairs, where you are not well aware about the complete facts, so if you try to delve into that arena or area, you will create problem not only for you, but then your other family members also. The question relating to others, you can very well qualify. Must. Either you may not remember, say you do not remember. You say you do not remember correctly. You do not know. And so therefore, you should know to the extent you are supposed to know. Any half-baked answer may land not only you in problem, but then to the other persons in respect of whom question was and you are replying. Because half-baked information may at times be dangerous information, may be dangerous. One should state the truth. There can be no quarrel. But then one should not remain under this, that in case the things have been stated correctly, your ordeal is over forever. Things should be stated truthfully, but then at the same time, you should also know the other facet of the truth, that your ordeal may well begin. It's not the end. If dumb documents are there, if paper does not speak, let it not speak. If you do not know, now don't traverse into the arena of speculations, because your reply, which is being recorded, that to an oath, will be an important piece of evidence against you. If anything illegal is done by the search team, as I said a little while ago, that public officers are presumed to act in good faith with no malice or no motive. There is a presumption. But then, if there are certain illegal things which are done by the search team, now one illegal thing which comes to my mind and which is not uncommon and which of late I have noticed, that certain documents are imported by the search team from outside. And that is why there is an important mechanism recognized by the board that an SSE is entitled to search a person who is part of the search team. But then that is highly impractical. When a person is bombarded with the search team accompanied by the police force, and to expect from him at that point of time to search the searching team, now theoretically it may appear to be very salutary, but then in practical, I mean, it doesn't, it is never that simple as it appears to be. But then if this illegal thing, like I remember in certain situations when the things were imported by the search team from outside, in certain situations, the SSE said, sir, it was not found from my office, my residence. It has been brought from outside, and kindly do not make part of it this Panchanama, or even if you are insisting upon making it part of Panchanama, kindly bring this fact on record. And that SSE brought this fact in his statement, and fortunately authorized officer did record that statement. In case of HSBC bank accounts, the information which came to the departmental authorities from that unauthorized source or from France, which had got nothing to do with that information because HSBC was in Switzerland, that was brought by the authorized officers inside, and then the SSC was confronted with that. But that was, you state that we have brought it from outside. So if certain illegal things are done by the search team, that searched person is entitled to bring it to the notice of the panchas, the witnesses. And may request the officer to record this fact that it was not found from here. And still, if the authorized officer doesn't record, though according to me there should not be any reason because he is a public officer, presumption of good faith is by his side, then SSC is entitled to write it as early as possible to the higher authorities. Though again, one may say it's highly impractical. A person who is under search, I mean, can so brazen in complaining against the searching officials, that is something which again looks very impractical. Jewelry, to the extent which is mentioned in the board instructions. Now, the board has advised officers not to seize if to the extent of that much of jewelry. But then when the items do not match from the wealth tax return or from the VDIS, then the authorized officers, they seize most of the times. They say, no, this jewelry which does not match with that item to item, now this is your undisclosed jewelry and there we will seize it. Now that is highly pedantic approach. And such kind of attempt to seize such jewelry on this pretext now is something unmindful of the household realities, where the ladies of the house, they frequently get their existing jewelries changed. But then later on, during the appellate proceedings, the court then take a broad view and say, now to that much of jewelry will be treated as explained and will not be treated as unexplained merely because the items do not match on piece basis. Due care, I'm sorry to say this thing, but then if I'm saying it, I have seen it, I've experienced it. Experienced through the briefings which are done. Due care should be exercised by the searched person as to the cash which is found, as to the jewelries which is found, as to other valuables which are found. Because lest they should disappear. Beyond this, I'll not say anything, but due care should be exercised. A statement is ordinarily recorded in English because English is the language of the court. But then if a request is made that the statement be recorded in mother tongue, then authorized officers I have seen, they record the statement mother tongue unless there is some highly impractical situations. But then in any case, the statement is recorded in English, and in case that person does not know, then it is liable to be, then the authorized officer should explain each and every question and each and every answer recorded in English to be explained in the vernacular language to the person who has given this statement. Chartered accountant and the counsel, they are not entitled to be present, and a searched person cannot, as a matter of right, ask for the presence of his counsels. But of course, if the authorized officers permit the entry of the chartered accountant or the counsel for the purpose of facilitation of the information, then of course they can be present, but of course they cannot interfere in the search or in the statement which is being recorded. Now, we have discussed about the rights. Now, We have discussed about the precautions during the course of a statement. Now, the third facet of today's discussion out of the entire topic is about the admission and retraction of statements. As I said a little while ago, that power to record a statement is there under section 131(1) capital A, that is called a preliminary statement, and a statement under section 132 subsection 4. And both the statements are recorded on oath. And there is a provision under section 132(4) that such a statement is to be recorded on oath and can be used as an evidence in any proceeding. Therefore, the evidentiary value of such a statement, whether recorded under section 131(1)(a) or under section 132(4), is very high. This is very high not only because of this fact that it is recorded on oath. It's very high because such statements are of contemporaneous nature. Contemporaneous nature means that these statements are statements at the time when the SSE, there is no possibility of the SSE being tutored or having been tutored. Therefore, such statements which are given carry a very strong evidentiary value. Now, that evidentiary value can be for SSE or can be against SSE. That is a different matter. But then that statement carries a strong evidence. And therefore, when there is an evidence, when there is an admission in the statement, then that admission can be used for the SSE, can be against the SSE. But then when we say admission during the statement, often it is an admission against the SSE, because admission or confession in the statement by the SSE mostly will be to the prejudice of an SSE. Therefore, the question arises when the statement is recorded in survey, which is also another investigative tool in the hands of the tax department, the statement which is recorded during the course of search, whether there is any difference between the evidentiary value of the two statements. Of course, the statement which is to be recorded during the course of survey is not required under the law to be recorded on oath. And therefore, the evidentiary value of such a statement, which is not required to be stated, which is not required to be recorded on oath, even if recorded on oath, the courts have repelled its evidentiary value in the light of the express provision of section 133A, that is the survey provisions. The courts have said that its evidentiary value cannot be of that genre which is attached to the statement which is recorded during the course of search. Nonetheless, a statement recorded on oath sometimes is believed as if no statement. I mean, with the utmost respect, I would say that may not be the correct understanding of law. Sometimes we tend to interpret the decision of the Supreme Court as if the statement during the course of survey has been recorded on oath, that statement has to be discarded at all. I mean, to that extent, I would respectfully submit and urge that that may not be the correct appreciation of law. Now, appreciation of law can be to this extent that the statement, even if it recorded on oath during the course of survey, is some piece of evidence, may not be of that weight which is attached to the statement recorded during the course of search. Therefore, in case of survey, if some statement is recorded, And if there is no corroborative material, then the courts have said that in absence of any corroborative material, the additions cannot be made. But in case of search, though I'm quite conscious that the judicial decisions are to this effect, that in case of search also, as if some corroborative material is required. But in case there is unretracted statement of search, then that statement by itself can constitute material having strong evidentiary value. And there may not be the necessity of any corroborative material. But what happens most of the times, that a person may have stated something on oath under section 132(4) during the course of search, but in most of the cases he retracts it. So once he retracts, then the presence of corroborative material now becomes essential. So kindly see, in case of search, if some statement is recorded on oath and it is not retracted, then that statement in itself becomes the conclusive piece of evidence. But if a statement is recorded on oath and search under section 132(4), which is retracted, then in the light of that retraction, the courts have said that we'll have to see the other corroborative material also. So this is the fine distinction. Therefore, in case of a non-retraction in search, the statement under section 132(4) itself can be the conclusive, because if a person has stated something on oath which he has not retracted, now what else is required? Admission is the best evidence against a person. Therefore, this fineness of the distinction, which is sometimes we may tend to ignore or miss, now that should be taken care of. Now, and every SSC has got a right to retract. There is no quarrel with that proposition. But the circumstances of retraction or circumstances under which that statement was made, which is sought to be retracted now, that is equally important. So if some force has been brought to bear upon a person to admit something or to confess something, then of course that statement cannot be said to have been given on that person's own sweet will, own volition. Now that force or coercion that have been brought to bear upon, or some misrepresentation has been made by the departmental officer or authorized officer before that concession was made by that person, that will vitiate. And SSC is entitled to retract it. But then the circumstances of retraction, that should also come in the retraction. It must be brought on record by that person as to what facts have undergone a change because of which the retraction is being made. Then another element of retraction is that it should be done as expeditiously as possible. Delay in retraction will be read against that person, will be read against that retraction. But then one bottom line which must be borne in mind is retraction or no retraction. I always say that even if I have said something which I have retracted, the very fact I have not included that admitted amount in my return of income is also one form of retraction. So if I had admitted something which I have retracted directly, indirectly, overtly, covertly, and there is no corroborative material, then of course no addition can be made. But then if there were some evidences which are corroborating, and even if person retracts, then how does it matter? Because that statement initially made, supported by the corroborative evidences which have been found or which have been discovered or which have been collected, then retraction ultimately may not be of any significant value. So ultimately, what percolates down as to what is the corroborative material which has been found or which has been discovered or which has been collected. I am conscious that the courts have taken judicial notice of the statements recorded under difficult situations. And courts have appreciated that. Kindly imagine a person who has been surrounded by the search officials who have breached into the privacy, have entered into your arena, house, residence, and investigation is being undertaken continuously. The psyche of a man. Now, all these things, the courts have started taking note of it. And one judicial decision in the case of Naresh Kumar Agrawal by Andhra Pradesh High Court, now it has become Telangana, but at that time, the combined Andhra Pradesh High Court and Naresh Kumar Agrawal, probably it is reported 360 ITAT. It is a treat to read that decision, where Honorable High Court has taken note of the circumstances in which a person who is being searched finds himself, and therefore has taken note of, what happens in searches. I remember there's a Gujarat High Court decision after the Ahmedabad bench decision in Pramukh Builders. The statements, the search action having been undertaken at a stretch for hours together, surrender being made in the wee hours of the day, in the early hours of the day. All these bits and pieces of evidences indicate that concessions, the admissions, the confessions made by a person may not represent the actual state, because all these factors indicate that person not to be in the correct state of mind. So admission and retraction depends upon the facts and circumstances of a case. There cannot be any blanket proposition of law as to what would happen in case the retraction is made, whether the admission would lose its evidentiary value altogether. It depends upon so many factors, as I just explained, I just discussed. So I have discussed about the rights qua the cash, jewelry, other valuables, rights qua the statement, evidentiary value, the statement recorded in search, and its distinction between the statement recorded during survey, rights as to the retraction. And as I said, it should be done in case one wants to retract, at least one should do expeditiously as possible. It depends again on the facts and circumstances. I remember in one case, an SSE conceded something, admitted something, and I remember he was to be taken directly to the hospital. And then a bypass surgery was performed on him. And therefore, it took about a couple of months before he could retract. The department's well-known stand was his afterthought. But then, in the facts and circumstances, where a person was admitted, operated bypass in a reputed hospital, now if he took about 2 months to retract, that can. So again, everything is dependent upon the facts and circumstances. There cannot be any blanket proposition. And so, I mean, all these things I just wanted to share, which I shared. If there are questions, now Jain Saab is also there, VP Gupta Saab and other stalwarts are also here. If there are questions, I will be pleased to answer them. So Jain Saab, VP Gupta Saab, now I will give quietus to my this deliberation. This stage is 1.5 hours. I leave the floor for the question answer session.
Jain Saab, may I request you to add, please?
Dr. Rakesh Gupta ji has explained all points very well.
Yes.
There are a few points for the benefit of we all. I would just like to place before you for your considered views. One is the jewelry and wealth tax. We are all aware that after 2015, wealth tax is abolished. We are not required to file the wealth tax return. Now, during last 9 years, almost 10 years, during this period, some lady might have been married, some new jewelry might have been purchased, some jewelry, as you has very kindly indicated, might be some remaking by the ladies. So in such a situation, it would have been better that wealth tax would have been continued and people would have allowed to file their valuation reports. And VDS was also long ago. So the government should consider as to how this arbitrariness on the part of the officers in considering a jewelry item or more than one jewelry items as undisclosed. And merely because there is a CBDT circular as well, that if the gold weight of the ornament is equal to the gold already declared, then whether the item matches or does not match is irrelevant. So this position also should be reiterated by the government. And this wealth tax, you see, people don't mind the limit was 30 lakhs. So it may be 30 lakhs, or if the government wants, they may decide a higher limit, maybe 40 lakhs or so. But then for the sake of transparency, so that people can make proper declaration, and attached with that, there are few points. As a piece of advice I would like to make is that even if there is no search or no inquiry as such, even then, if somebody received the jewelry at the time of marriage, then it is advisable to have an affidavit. Either if the person who donated the jewelry, if he or she is surviving, he or she can give the affidavit or certificate, or the other relative of that lady who is aware that these jewelries were presented by her other relative to her. So, or likewise, sometimes the jewelry is received as a gift at the time after the marriage on the normal functions in our families. So if these papers, instead of organizing these papers after the search takes place, should be there well in advance so that it is easier to explain. So these things should be kept in mind, and the affidavit about the jewelry or certificate, if you can get, because the persons who gave the jewelry, say 20 years ago, they may not be available now. So the CBDT should consider the things properly. And few points about the retraction of statement have been very validly made about the corroboration. And even in case of retraction also, not only a letter should be filed after the search, but it should be in the form of an affidavit. It is better. And if the affidavit, instead of just making an affidavit before a notary public, it is better if it is made before the first class magistrate. In my personal practice, I have seen that the value of a retraction affidavit before the first class magistrate has been considered much higher than the normal letter. Then you see witnesses. The witnesses, the law provides that in course of search, there can be two witnesses. And many times we find that the servants in the family, their name is noted as witness. But instead of that, if we can have a proper witness, those who understand what is a search, how it is conducted, then it's better. And in that case, the affidavit of witness is also can be very valuable. So instead of just noting, allowing the search party to note down the name of the servants in the family as witnesses, we should insist on proper witnesses, maybe on neighbor alike. And retraction should be elaborate as to why I am retracting, and we should highlight the error, what is the error in the statement, and we should inform the senior officers. After the search is completed, the retraction we should also bring to the notice of the senior officers of the investigation wing, and as suggested, even with the help of a case law, where somebody was admitted to the hospital due to a heart problem. So, but even in any case, the retraction earlier the better. So these things we should keep in mind. And the latest case of the Supreme Court yesterday, and that kind of case also came up before the Honorable Supreme Court earlier in the case of Raja Narayan Lal Bansilal versus Mr. Feroz Mistri, and also yesterday in the case of Mr. Arvind Kejriwal. The court cited Article 20, Sub-Article 3 of the Constitution of India, which says that no person accused of any offense shall be compelled to be witnessed against himself. But that is generally against the criminal laws. But at the same time, how far it can be used by the person who has been searched, we would like that Dr. Rakesh Gupta ji, because he practices in Supreme Court and High Court, how this concept is useful in the income tax search and surveys. So I would not like to take much of your time, and we would like to have the benefit of respected Dr. Rakesh Gupta ji on these issues and on other issues if he feels that something is left. Thank you, sir.
Yes, yes. Thank you,
Rakesh,
sir.
there are few questions in the chat box.
Yes, sir. Yes, sir. That I just saw. So should
So
I respond? Start responding them, sir?
please.
This question is
First
from
question you
Shri
already
Vaibhav
responded.
Chaudhary.
Yes.
If the CA/Council was present before the starting of the raid, can they go out or their belonging will also be seized? Now, there is a power of the authorized officer under section 132(1) which says that authorized officer can search any person who is inside the house, who is entering the house or is coming out of the house. So if a chartered accountant or a counsel is inside the house, then the authorized officer has got power to search him. And search him means search his person also. So in case the things are found from his possession and control, then they are liable to be seized in case they are found incriminating in nature. मुकेश जी का प्रश्न है, sir, as per section 132(4) word used in evidence and not used as evidence, so how it impacts proceeding? No, I mean, this is reading too much between the lines. It doesn't make any difference. Used in evidence and used as evidence. Something which is used in evidence is also partakes the character of evidence. Aniruddha ji कहते हैं, let me know whether a statement given by SSC during the inspection / raid can be retracted. That I've already read that it can be retracted. अमरजीत कंबोज सर कहते हैं, लुधियाना से हमारे मित्र हैं, सर, appraisal report made on the basis of documents found is a charge sheet against SSC. Why is it not shared? No, appraisal report is their internal document, and which may or may not be acted by the assessing officer, who acts as a quasi-judicial authority. So therefore, SSC cannot be said to have a vested right to have a copy of it. Now, if out of the appraisal report assessing officer wants to rely upon, then he is required to confront it to you. And therefore, I mean, we cannot make its comparison as a charge sheet. That is alien. Aniruddha sir is again saying whether the statements can be taken during the night hours and whether it can be other than the place of business of the office, business of the office of the officers concerned. No, there is no bar under the law to record the statement during the night hours, though certain decisions from the state human rights commissions are there, now which say that human rights cannot be usurped in the name of the search. But then there is no such law under the Income Tax Act which prohibits the department and authorities not to record a statement during the night hours, whether it can be other than the place of business of the office, place of the business of the office or the officers concerned. No, if the officers are recording the statement in their office of yours, then there is every possibility that the SSE would say, sir, the pressure was this was the reason for exerting the pressure. Even that itself becomes a piece of evidence to show that everything was not free and fair. But during the course of search, of course. But then instances are there when the statements are recorded at times in the office also. So, I mean, search is on, search is suspended, the statements are recorded in the office of the officers also. I mean, there is no prohibition that the statement cannot be recorded in the office of the officer. So these are the all questions. These are the questions which are there, and if there are other questions, then
Okay, there is one question.
yes.
Whether the statement of a person who is not a director but has
Yes.
made a disclosure of undisclosed income in the hands of the company is binding on the company.
अच्छा नीचे है, whether a statement given by a person who is not a director but has made an admission of undisclosed income in the hands of a company is valid or no. I mean, one director is stating on behalf of a company, company can resile from it and can say that it's not binding on me because the director was not authorized to make a statement for and on behalf of the company, and company is entitled to retract and say it like this, that this is not binding on the company. Vaibhav ji keh rahe, refer to my earlier question, laptop of a CA who is there already at the search site may contain data of other clients as well. So the data is not related to search party, but other parties also get implicated. It so happens in SR Botley Boys company's case, I mean, this situation arose, and court said that department should take the data of the searched person only and should not take the data of other clients also. But that we cannot say it in a very omnibus manner, because a chartered accountant is not having that privilege which lawyers have got qua the communication with their clients. And therefore, if there are data of other clients which are of incriminating nature and which can give clue to the department for some larger picture, and you can appreciate what do I mean by larger picture, then of course the department is entitled to take copies of those data and then can take the proceedings forward against those persons also. And chartered accountant cannot claim the right of privilege in respect of the data of other clients.
गुप्ता जी एक सवाल मैं पूछूं सर, डॉक्टर साहब अतुलपुरी बोल रहा हूँ।
हाँ अतुल सर हाँ सर।
सर इसके अंदर दो इश्यूज हैं, एक तो अभी मिस्टर जैन ने कहा कि वेल्थ टैक्स शुड बी रीइंट्रोड्यूस्ड, but there is a column and when you file the return, an assets and liability column is there, where you can give all the jewelry whatever you have. So department has given a window for that, so no need to bring in the wealth tax. And secondly sir, आपने कहा था कि such books and such documents, अगर वो तो जब आते हैं सर्च वाले, they take over even your mobiles, your laptops, anything that they can lay their hand. How much legality of that action is there?
Yes. Now coming to the first aspect, Atul ji, क्या था पहला एस्पेक्ट जरा बताना जो आपने बोला? हाँ, रिटर्न में मैं तो ये कहता हूं कि चलो रिटर्न में नहीं भी दिखलाया है. So I mean, so there are certain audiences from South, I will speak in English. So I go even to this extent that even if wealth tax is not there, even if requirement of filing a column in income tax return is there, yet a person does not show it in income tax return, but a person can otherwise prove from his bank account that the source of this amount is like this, then also it is possible. So disclosure in the return is a ready-made thing which can be shown to the department. Otherwise, if an SSE can show with the help of a privately kept balance sheet that here is the source, the question ultimately percolates down to the source. So if an SSE is able to explain the source, then that should be treated as explained, and department should not seize in that case. So return is only a medium of showing that there was a source, nothing more, nothing less. Second thing, they seize. Yes, they seize it. So long as their actions are bona fide, not mala fide, then it cannot be challenged. Why do you think that only unexplained or the documents containing unexplained transactions, will not be produced? Now, if NS, because if you see 132.1 first condition, that 131 notice is issued or 142.1 notice is issued to produce the books of accounts or documents which are not produced. These books of accounts may be the books of accounts containing your accounted for transactions. So, to say only those books of accounts or documents can be seized which contains the descriptions of unaccounted income or wealth, that is not the correct understanding. But normally, the documents or books of accounts containing the undisclosed transactions are expected not to be produced. That is a different matter. But then on that ground that they have made indiscriminate seizure of the books of account, therefore the search should be held illegal. No, that is not. That may not find favor from the courts. एक है फिर वैभव जी का भी यही था, कैन दे सीज द मोबाइल ऑफ द सीए लॉयर एज वेल. देखिए, एवरीथिंग, व्हाट इज मोबाइल? These are the documents, electronic documents. So if the documents possessed by a chartered accountant can be seized depending upon its nature, then electronic document can also be seized. But then they do not seize, they clone it. They clone it, and earlier they used to seize. And since they clone it, that is why Section 65B of Indian Evidence Act, all these things come in picture, because then that becomes the secondary evidence. Naresh ji कह रहे हैं, additions have been made by AO on the basis of the statement of a person who is not a director, assuming that he is a shareholder. Any case laws for the company to fight for other than the ground that the statement has no validity? Now, it depends upon the facts, what kind of additions was there, what kind of other nature of evidences were there. So the addition made solely on the basis of statement, that too from a person who was not a director. And if company says no, he cannot bind, then of course the appellate authorities do not have any option but to say no, he did, that cannot be made. Anything else? KK Singla sir का भी आया है कुछ, मैंने देखा नहीं, पटियाला से. Sir, what precautions we should take if some jewelry is kept with the search person by children living abroad? There should be some evidence mentioned then and there, like in the form of a slip or some confirmation from that person. Sir, this much of jewelry, belongs to the daughter or the daughter-in-law who is residing abroad. So there should be contemporaneous document or evidence which should be there. And if that is found, then that is a strong piece of evidence. But merely because that something like this is mentioned, that will also not absolve the searched person from all responsibilities. So it should not be a subterfuge. So in that case, you may be asked to prove further at that point of time before authorized officers may be persuaded not to seize it.
सर, अगर सारे क्वेश्चन आंसर हो गए तो आपसे 4 लाइनें सुन लें.
सर, आई फिनिश्ड
सर वोट ऑफ थैंक्स के बाद में.
सर, वोट ऑफ थैंक्स में कविता भी तो आएगी
भाई. आज तो सर्च ही रहने में यार, सर्च के बारे में.
सर, और कोई प्रश्न हो तो
और कोई अगर इसके बारे में
प्रश्न फिर आया है कुछ. कैन यू थ्रो सम लाइट ऑन सेकेंडरी एंड प्राइमरी एविडेंस ड्यूरिंग सर्च एंड एडिशंस बेस्ड ओनली ऑन सेकेंडरी एविडेंस? हाँ, ये बड़ा इंपॉर्टेंट प्रश्न है कि प्राइमरी एविडेंस और सेकेंडरी एविडेंस, प्राइमरी एविडेंस से सेकेंडरी एविडेंस जो बनाते हैं, यानी कि कोई इलेक्ट्रॉनिक डॉक्यूमेंट से फोटोकॉपी ली, तो दैट बिकम्स फोटोकॉपी बिकम्स द सेकेंडरी एविडेंस. हार्ड डिस्क को क्लोन किया तो क्लोन हार्ड डिस्क इज द सेकेंडरी एविडेंस. तो प्राइमरी एविडेंस की एविडेंशियल वैल्यू एक अलग है, सेकेंडरी एविडेंस की एविडेंशियल वैल्यू जब तक नहीं होगी जब तक सेक्शन 65B ऑफ इंडियन एविडेंस एक्ट का सर्टिफिकेट नहीं होगा. तो डिपार्टमेंट is committing this kind of an error for quite some time, and despite persistent judicial decisions coming from the highest court, the department is
Madhu,
losing heavily because of this.
Eh.
उपेंद्र भट्ट क्या कह रहे हैं, हमारे श्रीनगर से मित्र हैं. मैसेज इन चैट ऑफ मिस्टर गुप्ता, प्लीज रिस्पॉन्ड. सर चैट कौन सा है मेरे पास? चैट सर मेरे पास तो नहीं आया, यही है जो चैट खुला हुआ है.
क्वेश्चन बोल दे उपेंद्र अगर है तो.
उपेंद्र भाई बोलो कुछ.
सर अब तो 65 डेज का एक खत्म हो गया सर.
क्या चीज?
काकरा जी एक मिनट.
क्या?
ये क्वेश्चन मेरे ख्याल से तो कोई है नहीं, क्वेश्चन मिल नहीं रहा.
उर्वी
मिस्टर उपेंद्र अगर है तो क्वेश्चन आपने बताते हैं.
उर्वी तिलवानी जी कह रहे हैं, कैन द नोटिस अंडर द 140 बी इशूड बाय जेओ इन केस ऑफ सर्च्ड पर्सन और इट शुड हैव बीन इशूड बाय FAO as per section 151 capital A.
सर
हाँ,
Hello.
कौन?
can you hear me?
यस
Hello.
हाँ
यस
बोलिए सर.
Sir, can you have the video conferencing of the search proceedings?
क्या अशोक शर्मा साहब कह रहे हैं कुछ? क्या सर?
Can you have the conferencing of the search proceedings? Can you insist for that?
क्या सर? क्या है? I could not get you.
सर आप स्पीकर के
Video
पास जाके
conferencing.
बोलो, आपकी आवाज नहीं आ रही है.
वीडियो कॉन्फ्रेंसिंग कर सकते हैं क्या?
नहीं
we
नहीं,
insist for
इन्वेस्टिगेशन में अभी वीडियो कॉन्फ्रेंसिंग कॉन्सेप्ट आया नहीं है. हालांकि इस तरह का एक डायमेंशन ये भी है कि इन्वेस्टिगेशन भी वीडियो कॉन्फ्रेंसिंग से हो. तो अब देखिएगा कब तक होते हैं ये.
राइट सर, थैंक यू.
I think everything has been explained very well, Dr. Rakesh. Thanks a lot. Now,
बात
may I request Mr. Kakra जी. हाँ जी बताएं जैसा.
गुप्ता जी एक सेकंड. गुप्ता
हाँ
जी,
जी हाँ जी.
ये क्या है कि इनकम टैक्स रिटर्न में जो ज्वेलरी या एक्स्ट्रा असेट जो बैलेंस शीट में नहीं दिखाई हुई है, वो उस कॉलम में दिखानी पड़ती है जहां पर जिसकी इनकम टैक्स पेयर की 50 लाख से ज्यादा हो.
करेक्ट.
इसीलिए मैंने ये बात आप लोग के सामने रखी कि वेल्थ टैक्स का प्रॉपर रिटर्न जाए और सब चीज डिक्लेयर है तो अच्छा रहे. दूसरी बात सर, हम लोग के बीच में तो हर आदमी जो हमारे बीच में अटेंड किया है, हम सबको इम्पोर्टेंस देते हैं और सबको नमस्कार करते हैं. हम लोग के बीच में DR सिंगल साहब, समीर जानी जी जो नेशनल डिप्टी प्रेसिडेंट है, एक्स ITAT मेंबर ऑनरेबल मेंबर सुशील प्राणसुका जी, जयपुर के महेंद्र गर्गे जी, अश्विन आचार्य जी, MM वसीन साहब, नितिन गौतम साहब, और मैं जिन जिन लोग का नाम देख पाया, मैंने कुछ लोग का नाम लिया है. तो सब लोगों ने, इतने लोगों ने आज हम लोग के बीच में शामिल होके और आज की वेबिनार को सफल बनाया है. ये औपचारिक रूप से जो वोट ऑफ थैंक्स है ये हमारे काकड़ा जी देंगे. तो
सर मेरा एक प्रश्न है, मैं पूछना चाहूंगा.
हाँ, सौरभ दुबे जी बोलिए.
जी सर, मेरा एक प्रश्न है गुप्ता सर से और आपसे भी, सभी लोगों से, कि सर ये भी देखा गया है कि जब सर्च होती है तो अगर ऑफिस प्रेमाइसेस में सर्च है, वहां अगर कैमरे इंस्टॉल्ड हैं तो अधिकारी उस कैमरे की रिकॉर्डिंग को बंद करते हैं इंटेंशनली.
करते हैं.
तो क्या ये करना ठीक है सर? और इसके पीछे उनका आर्गुमेंट ये होता है कि नहीं, मैं नहीं चाहता कि किसी भी चीज का कोई गलत इंटरप्रिटेशन निकले.
देखिए तो सब जो जिस वजह से करते हैं, इट इज रिटन ऑन द वॉल, उसको डिस्कशन करने से ही क्या पर्पस है. हालांकि उनको इस तरह से रिकॉर्डिंग को बंद करने का अधिकार नहीं है.
जी हाँ.
ठीक है ना.
जी सर. और सर एक और चीज है कि अभी GST के बाद से भी सर ये सर्चेस बहुत ज्यादा हो रही हैं, जिसमें प्रोफेशनल्स जो हैं, चार्टर्ड अकाउंटेंट्स वगैरह, इनकी प्रेमाइसेस में भी सर्च काफी इनिशिएट हो गई हैं. तो आज नहीं, कभी चाहूंगा कि आप कभी इस बारे में भी कुछ हम लोग को गाइडेंस दें.
चलिए सर, फिर कभी रखेंगे.
बिल्कुल बिल्कुल.
हाँ उपेंद्र भाई बताइए. हाँ उपेंद्र, आवाज नहीं आ रही.
हाँ सर, मैंने क्वेश्चन किया था. The assessing officer is also the officer who was investigating officer who made the scrutiny report. Is the order legal? Can he make it?
Yes. Because even the Supreme Court has said that if an investigative officer who conducted search becomes the assessing officer, there is no illegality.
Thank you.
May I request Kakra Saab to please give a formal thanks?
Thank you, sir.
काकड़ा
It's
साहब को तो
my
ब्लेसिंग्स चाहिए,
proud
थैंक्स से थोड़ी काम चलेगा।
Sir, no. It's my proud privilege to offer a lot of thanks. But I request Dr. Sir that after vote of thanks, please हमें 4 लाइनें आप अपनी कविता की जरूर सुनाइएगा। आज हिंदी दिवस है, तो हिंदी दिवस की सबकी शुभकामनाएं।
अरे सर,
सर ये सर्वविदित अनुभव किया हुआ सत्य है कि शुद्ध मन से आप जब वक्ता को निमंत्रण देते हैं तो देवीय शक्तियां भी वक्ता के प्रभाव मंडल को ध्यान में रखते हुए दिन और समय का उसी अनुपात से व्यवस्था करती है, चुनाव करती है। इसका उदाहरण है आज का ये हिंदी दिवस, जिसमें हमारे इस विषय पर तलाशी और जब्ती विषय पर विवेचन करने के लिए हमारे डॉक्टर साहब है और साथ ही साथ वो हिंदी लिटरेचर के अंदर में अपना प्रमुख स्थान रखते हैं। तो हम उनसे अनुरोध करेंगे कि बाद में अपनी 4 लाइन की कविताएं जरूर सुनाएं।
सर मैं ढूंढ रहा हूँ।
रहेंगे सर, आज का ये तलाशी और जब्ती विषय पर हमारे बीपी गुप्ता जी की अध्यक्षता में आयोजित डॉक्टर राकेश गुप्ता जी का इस विषय पर सारगर्भित विवेचन एक यादगार बनकर हमारे जैन में रहेगा। हम सब इस सुंदर विवेचन से भरपूर लाभान्वित हुए हैं और तो और हमें एक पर एक बोनस मिला है। हमारे नारायण जी नेशनल प्रेसिडेंट के जो सहयोग किया और बाद में जो हुए वो भी बहुत सुंदर है। मिले स्वर मेरा तुम्हारा तो स्वर बने हमारा। तो आज का यह सेशन एक यादगार सेशन के रूप में हम सब में जैन में रहेगा। अब अपनी 4 लाइन की कविताएं या बड़ी भी हो तो कोई असुविधा नहीं है, क्योंकि हमने समय दिया था 5 से 7, तो 10 मिनट तक हम सुनते, कोई असुविधा नहीं है। धन्यवाद सर।
अच्छा, चलिए सुनाता हूँ मैं सर।
राकेश जी सुनाई दीजिए प्लीज।
स्वागत है।
मैं चूंकि वृंदावन से हूँ तो इसलिए उसमें ब्रज की बातें
राधे
हैं,
राधे।
कृष्ण की बातें हैं। अब गोकुल हूँ वृंदावन हो, यमुना जी चरण पखारन हो। अब कालिंदी सुंदर तट हो, यमुना का बंशी वट हो। कृष्ण सांवला सलोना हो, बालहट चंद्र खिलौना हो। मन मंदिर बांके बिहारी हो, राधे श्याम बलिहारी हो। उद्धव का ज्ञान प्रखर हो, गोपी कृष्ण प्रेम मुखर हो। ना कंस का कारागार हो, ना बोध शिशु संहार हो। चाहे जरासंध बलशाली हो, पर तृण संकेत न खाली हो। चाहे शिशुपाल की गाली हो, पर अभय कृष्ण क्षमाशाली हो। कुंदुक यमुने में प्रवाहित हो, और कालिया नाग मरमाहत हो। वधपूत ना बकासुर हो, द्वैदाऊ कृष्ण संहारक हो। ना दधी मटकी से दूरी हो, कृष्ण सखा रुचि पूरी हो। यशोदा की मीठी प्रताड़न हो, विराट स्वरूप मुख दर्शन हो। ब्रज रज कबहु ना तजना हो, कभी त्वजे द्वारिका बसना हो। यत्र तत्र सर्वत्र हो, यत्र तत्र सर्वत्र हो। थैंक यू सर।
थैंक यू
सर आपने तो पूरे कृष्ण जीवन।
थैंक्स अ लॉट राकेश फॉर योर डेलिब्रेशन एंड आल्सो फॉर द कविता।
राकेश सर आपके मुरीद हो गए आज हम।
अरे
नहीं, थैंक्स अ लॉट
सर
राधे राधे तो कहना पड़ेगा।
गुप्ता जी अभी 7 बजा नहीं है, एक कविता का और भी टाइम हमको
हाँ
सुनने
जी,
का।
हाँ जी, बिल्कुल एक और सुनाइए
सर
सर। अब 111 रह गए, सब जा रहे हैं, वरना तो फिर कभी और सुनाऊंगा सर।
नहीं गुप्ता जी,
हाँ जी,
जी
वो
जी
है ना, कहते हैं भाई राधा रानी को कहना पड़ेगा ना
हाँ,
कि ताई आईन की छोकरिया छठिया पर छाछ पे छाछ पे
छाछ
चावे।
छाछ में चावे, हाँ था रस खान ने लिखा था।
हाँ जी,
हम्म,
बहुत बहुत धन्यवाद सर।
अच्छा, नमस्कार जी, थैंक यू सर,
चलो
थैंक
चलो,
यू,
थैंक यू, थैंक्स ए लॉट।